there are many challenges in hosting a live show 10 hours a week. I could go down a litany of them. I could do it in alphabetical, chronological, or in order of absolute danger. But one of the ones that's the most difficult to overcome is convincing Bill Stubblefield the show is back on and to stop doing what you're doing during the commercial break because it's time to do the show again.
I have an obligation.
And this only happens 8 times a day, 3 times a week.
Come on now. I have an obligation to one of our Facebook listeners. She asked a question, and I was trying to respond to the question. And fortunately, the Miss Manley has given some contact information. She's going to follow up with a board pharmacist. So she was not aware of the situation that the Facebook contributor offered or asked for, but she's going to follow up, which I thought was good. So I'm just trying to do my civic duty, Rob, trying to keep the communication bands going.
Good morning, Maria. How are you?
I'm great.
See, one of the challenges of doing a live show is when the commercials stop, it's time to do the live show. So everything else is supposed to be put to the side, and you go to the live show. Now, I didn't cover that during live show boot camp like I should have. I should have really emphasized that.
Let the record.
We are wonderful volunteers, so we just do what you tell us, Rob.
And let
some of you do, and then some of you just do what you want to do.
Let the record show, by the time the red light went on, I had finished my communication and I was giving you my full attention. Now,
such as it is.
Now, prior to the red light going on, you're right. I was doing other things.
Let's bring.
I'm going to push back, Rob.
I'll bring Bonnie into the studio a couple of days a week to keep a handle on this guy over here.
Good heavens!
That's our co-host there, the Admiral Bill Stubblefield and Maria Lorensen. Welcome back to both of you.
Thank you.
And
happy to be here.
Guest in this segment is someone you are quite familiar with, Maria.
Indeed, indeed, he is.
Will Lorensen. He is the person who's in charge of everything in Berkeley County that Maria is not in charge of.
Thank you very much for having me.
You've also got to throw the judge in as well, because there's a niche the judge has responsibility as well. But the three of them just about cover the county.
Will has the best attitude a son of a person of Maria's ilk could have. And I'll give you an example of this, right? So last year at the hospice event at the Bavarian, I go strolling over into a room. Coincidentally, that's where the bar is. And that's coincidentally where Will was hanging out.
There was no seat.
No seat for Will.
He knows he never gets a seat.
And
I don't need one.
Will looks at me and goes, hey, I said, how you doing? He said, well, whatever my mom needs done here, that's what I'm doing. He said, I don't actually have it. I said, where are you sitting? He said, I don't actually have a table. There wasn't any room for me, so I'm just kind of standing around. I kind of, do what we need to have done. And I said, that's a remarkable attitude for a son to have, because, a lot of sons don't have that kind of cooperative attitude.
Yeah, I've done a lot of arm twisting over the years. I think most people know and, understand that Will and his father are very good cooks. And
you don't cook.
Yes, and one of the things that I have talked Will into doing was offering his services to be auctioned off, and as a meal for, you prepare a meal for 6, 8, 10, whatever the folks generally want. He goes into someone's home and does that. And after the word gets around, so sort of the nonprofit community then has reached out to him, and he's like, I'm going on sabbatical. I am done. And then this year, we sort of had a need, and I was like, Will, just one more big one. And he couldn't say no.
And
he's a good son.
And I want to add a story as well. This past hospice, I had kind of an unfortunate event. I walked back into the bar where Will and Maria are holding court. I was wringing wet. I was somewhat frustrated, and it was
before or after the tire thing.
This after the tire thing, yeah. And Maria gave me a flippant comment, and Will very quickly jumped on his mother and said, there's a time to be flippant. There's a time to be serious. This is the time to be serious. And Maria immediately said, yes, son. And that's what she did.
I thought Will was going to say this is the time to be seriously flippant. I thought he was going to marry the two.
Yeah.
Will is the fiduciary supervisor of Berkeley County. Will, welcome back to the show. Good to have you.
Thank you very much. As I say, it's very pleased to be here. And I want to commend you, Rob, for having Ms. Manley on right before me. Great programming by you. If you do not heed Miss Manley's warning, you end up in my office, which is probate. So kudos to you.
Yeah, it's all flowing. It's all about the flow. What is the difference between the fiduciary supervisor of Berkeley County and the county attorney?
So the fiduciary supervisor, probate in West Virginia stems via our Constitution through the county commission. It does not originate in the judiciary at all. So I serve at the pleasure of the county commission. Fiduciary supervisor is an optional procedure. The original, mandate of our Constitution deems that probate is handled through the county clerk's office. And what happened in 1984 was that county clerk's offices really didn't know what they were doing with regards to probate. And so the legislature said, okay, well, if you want to kind of circumvent that authority, we will have this fiduciary supervisor position where you'll have a lawyer, typically a lawyer, it's now all exclusively lawyers, to handle basically a probate office. Obviously we're a subset of the county commission, and obviously the county attorney, the legal director for Berkeley County also works for the county commission, but in various different ways. We are probate and probate only. We have 3,000 open estates.
Define probate.
Probate is the legal means by which decedent's either assets or, final business are adhered to, meaning if you are inheriting a piece of property that is solely owned by a decedent, the only way you're going to do that is through this process that we call probate. The other reason why people open probate is to gain legal authority over a decedent's final business, meaning if there's a lawsuit that needs to be filed, you must open probate. If taxes need to be filed, the only way to do that is through probate. In a more basic sense, think of it a relationship between two living people for a power of attorney. That's what probate is between a living person and a now deceased person.
And I would have to be a resident of Berkeley County who passed away to be under the jurisdiction of your office.
That is our typical scene of scenario. I mean, if you're a resident of Berkeley County, that's the first question we ask. If you own real estate in Berkeley County, and there's a question as to where you are a resident of, that also opens the door for my jurisdiction. If you own no real estate and you just have stuff within the bounds of Berkeley County, that also opens up jurisdiction for my office.
So if I have multiple residences and property in various locations, regardless of where I pass away, if some of that property is in Berkeley County, my heirs will need to deal with Berkeley County probate?
In one way or another, yes, especially if it's real estate, absolutely.
Is this a relatively quick process? Does it take time, and do I need an attorney on my own right to go through it?
I'm going to give you the best lawyer's answer you've ever heard. It depends. That's
an accountant answer too, by the way.
Yeah.
To answer your first question, is it a quick process? It depends on you. You as a personal representative or would-be personal representative of an estate drive this boat. It also depends on what the decedent had. If they had, for instance, for the small estate law, if you have $50,000 or less in tangible and intangible assets, i.e., money, vehicles, tangible assets, coin collection, whatever it is, and it's $50,000 or less, all you have to do is meet the prerequisite requirements and file an affidavit, and then you have 6 months to do whatever you need to do to transfer title of those assets, and you're done. That's the small estate procedure. Classic probate, the 3 steps, the 3 documents filings, can last as little as 6 months. Can go. We have estates that have been decades long.
If I do not have a will, does this complicate the process?
It does and it doesn't. I got to be honest. And this is part of what I want to communicate to the public. almost all of the most complicated processes that I've seen, probates that I've seen, have been not from folks who don't have a will, but from folks who thought they could do their own will. And that bad estate planning complicates things to a whole new level, rather than not having a will. The code has a way, it's called descent and distribution, also called intestate succession, where the code tells us where stuff goes. It's split evenly between your children, your surviving spouse, your brothers and sisters. It depends on what your family dynamic looks like. But, I mean, that is a clear and concise answer of where your stuff goes through the code if you have no will. If you have a will and you're weirdly vague and you don't give away all of your stuff and you cross out things and try to write into the margins, that becomes a question of fact. And then all of your stuff, rather than going to your loved ones, goes to lawyers. And those lawyers' kids get braces now because of you.
And is it a coincidence that your name is actually Will?
It has been brought up to me many, many times, and I thank you, Rob, for that. Wills has come up plenty of times.
Eddie Gokenauer says that a lot,
all
doesn't
the
he?
time, and it never gets old. So it's wonderful. It's wonderful.
Thank you, Eddie. And if I have a surviving spouse, and we were currently married at the time of my passing, does that make it easier as to where everything goes?
Yes. So your surviving spouse, West Virginia has many. I've said this to people, and it always makes their eyes widen. You cannot disinherit your surviving spouse. It cannot happen. If you want your surviving spouse to get nothing, divorce them.
It sounds like that's a too common question.
Oh my goodness, it is.
Wow.
You cannot disinherit your surviving spouse. I don't care what they did to you. If they're married, they have a statutory right called an elective share that they can sit there and say, look, I want, I'm entitled to, whether it be 50% of the estate's assets, but classically that is the surviving spouse's rights. If there are children only within the marriage and there is no will, then surviving spouse takes 100% of everything. So, yeah, if you have a surviving spouse, it makes things clear and easy as far as no will.
Is it true that you got an email about that by a person trying to disguise his identity? He signed it Admiral B.S.?
I can neither confirm nor deny. No, kidding. Of course not.
Yeah, we are kidding, Rob.
Go ahead, Bill.
Yeah. Will, you mentioned 3 documents. What are those 3 documents?
West Virginia probate is actually immensely simple. I mean, obviously, it can get complicated throughout the rings, but there are only 3 documents, as the Admiral has said, that you need to fill out. Each document is answering a specific question. Step 1, or document 1, is answering who are the parties involved in this estate, who's deceased, who represents the deceased, and who are their heirs or beneficiaries. That's it. That's all you're doing. That's step 1. Who are the parties involved? Step 2 is called an appraisement. That's where you go out and do some due diligence and report to the West Virginia Tax Department what's actually in the estate. That's the second question it's answering, what's in the estate. The third question, the final step, which is settlement, is where's all the stuff going? And those are the 3 steps of probate. It gets very complicated in the interim, but as far as the documents you have to fill, so in answering Rob's earlier question, do you have to have an attorney? No, but in answering those more complicated, well, I have a stepbrother twice removed that may or may not have been adopted by my grandmother, and then my grandmother, you want to talk to an attorney in those instances. My office is very probably not going to be able to help you with that.
Who's responsible for these 3 documents? The executor of the will?
The executor of the will, the personal representative of an estate. So even if you don't have a will, the administrator of an estate is responsible. They drive this bus. They are responsible for the information within those documents. They submit them under penalty of perjury. And if you're intentionally misrepresenting the estate for your own benefit, that is also a crime.
Describe what you mean by the administrator of the estate.
An administrator of an estate is simply an executor without a will, right? They pretty much mean the exact same thing. An administrator is just a term of art. It simply means that there was no will. A person has very kindly or in whatever means, very selfishly, volunteered to come forward and represent this estate's business during the duration of probate.
If there's competition between, say, family members, how is that resolved?
So the code actually has a lovely vague term for this. The fiduciary supervisor has the authority to deem the, quote, appropriate, unquote, party. So that sometimes falls on me. If there's literally one brother comes into an estate, another brother comes in as that person's trying to qualify, say, no, I want to do it, I'm going to immediately set this for hearing before the county commission. And if the county commission and the parties can't come together to some kind of an agreement, then I'm going to assign what's called a fiduciary commissioner. A fiduciary commissioner is a private attorney that basically mediates estate conflicts that I assign.
Yeah, as a county commissioner, I think the only part of the job that I found to be distasteful was trying to resolve conflicts within a family regarding a will.
It is it's what our Constitution mandates, and I agree with you. It gets very uncomfortable very quickly because, again, most of these folks don't have legal representation, so you're literally seeing a knockdown, drag-out fight in a public sense that is recorded on public record.
That can't be fun. That question I got from in a text from Financial Phil, and he asks, can you clarify surviving spouse? If it's an account where you can name a beneficiary, you should be able to name someone other than a surviving spouse. Example, children, brother, sister, best friend, whoever it may be.
Absolutely. It's important to, and I'm glad you brought this up, it's important to understand what we're talking about is probate assets, assets solely titled to the decedent. The prompt that Financial Phil has brought up is what's called a non-probate transfer. You're talking about title that passes to another person that may or may not be the surviving spouse. That being said, Financial Phil, if a surviving spouse, let's say this decedent owned nothing in their own name and gave everything non-probate to their family member, as I say, the surviving spouse has a mandate or has a right to an elective share, and they can say, I want 50% of the in total gross assets, and that includes non-probate assets. So the answer, again, is it's wonderful. It depends.
Surviving spouse has power, though.
They very much do. Yeah, it actually goes back to ye old England, and we don't want widows to be in gutters in the street. It's a public policy thing, and West Virginia followed suit, and surviving spouse has immense power.
Maria, try to confine your questions to the current topic and not whether Will has learned to pick up in his room yet since his childhood days.
Actually, it's a good question. Is there and not that we talk about this at home, but is there a statute of limitations? Or you made reference to estates that have been open for decades. So no time limit at all.
So technically, if you open an estate and that estate goes on for years, there are two mandates that the code requires. One is an annual accounting. You, as the personal representative, have the mandate to report to my office what estate assets are in the estate, what you've done with those assets, and where they are. That's an annual requirement. If you're holding $800 or less, and you can show that to my office with sufficient proof that I'm satisfied, then the annual requirement is pushed back to every 3 years. So yes, there are mandates, and there's also a way that my office can administratively close the estate, but nothing happens automatically, not in probate.
And then if somebody's not listed, not named in the will anywhere, can they contest it?
Absolutely.
Okay.
So if a will is legally valid on its face, that's what my office determines. If a will, meets the bare minimum legal requirements.
And that can be handwritten, it can be anything.
Yes, it can. Okay. If it meets that requirement, then we accept it. Then you're talking, if you want to contest a will, now you're talking about appealing that decision. And because I'm an arm of the county commission has already spoken on whether or not this will is valid. It is, to the county commission. Therefore, you are appealing that to the circuit court for appealing that. So.
Well, there have been instances in the county of someone preparing a will, probably over several years prepared will, but they've never taken to the final step. They've never had it notarized. What weight does a unnotarized piece of paper carry in the probate discussion?
Sure. So there's actually in the code requirements for a valid will, a notary is not required. So long as you have two witnesses attesting, they don't actually have to attest to anything, but so long as you have two witnesses who actually saw the execution of the will, and those two witnesses are what's called disinterested, they don't get anything, or if they do get something, they only get what they would have gotten so long as there wasn't a will. But essentially the code says there is no attestation required. So, it does make things easier because the person holding the will then may have to subsequently prove the will's validity. And they can either ask for the county commission to move forward through what's called solemn form without proof, or they can go track down those witnesses from years and years ago and say, hey, here's a form signed to the circumstances that you saw witnessing that will.
So talk a little bit about these entities that are out there that say, hey, you can go online. I'm not going to name one of them, but they appeal to the nonprofit sector often and say, hey, you have a number of people who have used this online document and they're leaving you money, and if you'll kind of let people know that this is out there, then we're going to let you know more people who are going to leave you money. Talk a little bit about the online will.
If an attorney did that, we have they have rules in their professional modes of responsibility. They would be at the very least suspended, if not disbarred. It is a highly problematic thing that nonprofits will, without any kind of estate planner or attorney advisable, they'll print something off of online or whatever, and they'll just type in and they'll provide you with witnesses and what have you.
You're better off to write your own then if you're going that route.
Again, it depends, but I would say honestly the best possible outcome for any individual is to go to a practitioner who does this for a living, i.e. a licensed West Virginia attorney, and prepare a will for you. You're giving away hundreds of thousands of dollars in real estate, your own assets. Why not spend $400, $600, $800 for a consult and a basic will?
Another question from a listener/viewer. Ask how you get someone off of a will that they're not doing their job.
Presuming that the will has already been probated and
you've already finished it up, and now you want to change it.
You can petition during probate through my office. That's part of what my office's mandate is to ensure due process. So if you're an interested party, like you can't just come out of the cheap seat saying, "Hey, I don't like that Tommy Smith. I think he's full of it," or whatever. You have to have something at stake. It's called standing. So if you have standing, meaning you're taking something through probate, and you don't like the way that an executor or a personal representative is handling your estate, you can file a petition. You yourself would have to form that petition, assert the legal or fiduciary duties you're asserting that have not been met, and you'd like to plead for relief, i.e. I want this person removed and I want either myself to be nominated or what have you. That happens at the county commission level, and I typically, if you're asking for a removal, would assign a fiduciary commissioner.
Will, good stuff. Is there a last quick question for Will?
No, I want to congratulate you. We got several very favorable comments on the Facebook. Good information, well explained, quite articulate. Well done, Will.
Thank you.
And a bunch of them said, Maria, nice job raising this young man.
Nice job, Maria, bringing Will in.
Very nice job, Maria.
You're welcome.
Now go clean up your room.
Yeah.
Yes, sir.
Will Lorensen, Fiduciary Supervisor for Berkeley County. Thank you, sir.
Thank you.